Hello guys! Welcome to my channel, Attorney JMF Vlog. Hope everyone is doing great. Good day, Miami side. This video is our first video lecture for criminologist licensure examination. Miami side future criminologist, criminal jurisprudence, procedure, and evidence is 20% of your board exam. That is why you need to get a high score in this subject. And the subject to be discussed in this video is criminal procedure. But before we start our lecture proper, please do not forget to subscribe my channel and hit the notification bell below to keep updated of our new lectures and videos. Criminal procedure, part 1 of this subject is the general principles. The law on Philippine criminal procedure, AM number 00-5-03-SC, which was approved by the Supreme Court on October 3, 2000. The date of effectivity is December 1, 2000. What are the sources of our law on criminal procedure? We have number 1, Rules 110 to 127 of the Revised Rules of Court as amended by AM number 005-003-SC. Second, 1987 Philippine Constitution, particularly those under rights of the accused under Article 3 Bill of Rights. Third, various acts passed by the legislature like PP 129 as amended by Republic Act number 7691. Civil Code, particularly Articles 32, 33, and 34. Presidential decrees, executive orders, and decisions of the Supreme Court. So what is criminal procedure? When you say criminal procedure, it treats of the series of processes by which criminal laws are enforced and by which the state prosecutes persons who violate penal laws. As applied to criminal law, procedural law provides or regulates the steps by which one who has committed a crime is to be punished. Ibig sabihin, sa criminal procedure, pinag-aaralan natin ang mga proseso o hakbang kung paano natin masasampahan ang kaso o isasakdal ang isang taong lumabag sa batas at kung paano siya mapaparusahan ng naaayon sa umiiral na batas. Kasama na din dito kung ano-ano ang mga karapatan ng isang akusado at kung ano-ano ang mga prosesong kinakailangan niyang gawin upang mabigyan siya ng pagkakataon na maipagtanggol ang kanyang sarili, lalong-lalo na sa mga pagkakataong wala namang sapat na basihan ang kasong isinampa sa kanya. What are the systems of criminal procedure? We have first, the inquisitorial system. Second, accusatorial or adversarial system. And lastly, mixed system. When you say inquisitorial system, it only means that the detection and prosecution of crimes are left to the initiative of officials and agents of the law. The procedure is characterized by secrecy and the judge is not limited to the evidence brought before him but could proceed with his own inquiry which is not confrontative. Ibig sabihin, sa inquisitorial system, nasa kapangyarihan ng mga otoridad at mga alagad ng batas tulad ng mga pulis, NBI at piskalya ang tuklasin ang mga krimen na nagaganap sa lugar na kanilang nasasakupan at maging ang pag-uusig sa taong nasasakdal. Isang halimbawa din ng sistemang ito ay ang kapangyarihan ng judge na magpalabas ng warrant of arrest na kung saan tinitingnan at pinag-aaralan niya kung meron ba talagang probable cause ang kasong isinampa laban sa akusado bago siya magpalabas ng kautusan na arestuhin ang isang akusado. When you say accusatorial or adversarial system, it contemplates two contending parties before the court which hears them impartially and renders judgment after trial. The procedure is confrontative and the trial is publicly held and ends with the magistrate rendering the verdict. Sa sistemang ito, ipinapakita na mayroong isang hukuman na tidinig sa kaso na kinasasangkutan ng at least two parties. Halimbawa, sa part ng plaintiff, people of the Philippines, at sa defense naman ay ang akusado. Dito ay sinasagawa yung buong proseso ng pagdinig na kung saan napakahalaga na may cross-examination ng kabilang partido ang bawat testigo na ipipresenta sa hukuman. Maaari ding magtanong ang judge sa mga testigo upang higit na malinawan sa mga pangyayaring naganap sa isang kaso upang sa gayon ay makapagpalabas siya ng isang desisyon na naaayon sa mga facts na inilatag ng dalawang partido at batas na applicable sa kaso. The essence of the accusatorial system is that the burden of demonstrating guilt falls on the prosecution. The standard to satisfy the constitutional requirement of the presumption of innocence being overcome is that capability be shown beyond reasonable doubt. Napakahalaga sa accusatorial o adversarial system na mapatunayan ng taga-usig o prosecution na ang nasasakdal o ang accused ay mapatunayang nagkasala beyond reasonable doubt. Walang kaduda-dudang siya ay nagkasala. Remember that the quantum of proof required in criminal cases is proof beyond reasonable doubt. Huwag kalimutan dahil itatanong ito sa board exam. What is the mixed system? When you say mixed system, it is a combination of the inquisitorial and the accusatorial system. Thus, the examination of defendants and other persons before the filing of the complaint or information may be inquisitorial. This is particularly true in the preliminary examination for the purpose of issuing a warrant of arrest. Under the rules on criminal procedure, a criminal action may be instituted by complaint of the offended party or by information filed by the prosecutor, and once the criminal action is filed in court, the accused has the right to confront and cross-examine his accuser. Ibig sabihin, kapag preliminary examination or investigation at bago magpalabas ng warrant of arrest ang hukuman, ito ay proseso na tinatawag na inquisitorial. Kapag nagkaroon na ng jurisdiction ang korte, papasok na yung tinatawag na accusatorial o adversarial system. Liberal interpretation of the rules. The rules on criminal procedure, being part of the rules of court, shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. Ibig sabihin, sa criminal procedure, hindi strict, bagkus lenient ang construction o interpretation ng mga probisyon nito upang higit na may sulong ang mga layunin nitong magkaroon ng isang patas na pagdinig, mas mabilis na proseso at sa pamamaraang hindi kinakailangang gumastos ng malaki ang mga partido sa kaso at maging ang ating estado. What do you mean by due process in criminal proceedings? Due process in criminal proceedings is mandatory and indispensable and cannot possibly be met without a law which hears before it condemns and proceeds upon inquiry and renders judgment only after trial. Under Section 1, Article 3 of the 1987 Philippine Constitution, it explicitly provides that no person shall be deprived of life, liberty, or property without due process of law. So what are the requirements of due process in criminal proceedings? Number 1, that the court or tribunal trying the case is properly clothed with judicial power to hear and determine the matter before it. Again, that the court or tribunal trying the case is properly clothed with judicial power to hear and determine the matter before it. Siyempre, napaka-importante na may jurisdiction o kapangyarihan na dinggin ang isang hukuman sa isang kaso na ipinail dito. Second requirement, that jurisdiction is lawfully acquired by it over the person of the accused. Again, that jurisdiction is lawfully acquired by it over the person of the accused. But how does the court acquire jurisdiction over the person of the accused? Paano nagkakaroon ng jurisdiction ang hukuman over the person of the accused? The court acquires jurisdiction over the person of the accused by his, number 1, arrest, or number 2, voluntary surrender. Ulitin natin, nagkakaroon ng jurisdiction over the person of the accused kapag siya ay naaresto o voluntaryong sumuko sa hukuman. The court acquires jurisdiction over the person of the accused by his arrest or voluntary surrender. Tandaan ang mga bagay na ito at posibleng lumabas ito sa board exam. Third requirement, that the accused is given an opportunity to be heard. Again, the third requirement requirement is that the accused is given an opportunity to be heard. Binibigyan din ang akusado ng karapatan at pagkakataon na madinig ang kanyang panig. And lastly, the fourth requirement is that judgment is rendered only upon lawful hearing. Again, judgment is rendered only upon lawful hearing. Naglalabas lamang ang hukuman ng isang desisyon matapos ang isang masusing pagdinig sa dalawang panig sa isang partikular na kaso. What do you mean by criminal jurisdiction? What is criminal jurisdiction? It is the authority to hear and try a particular offense and impose the punishment for it. So what are the requisites for a valid exercise of criminal jurisdiction? So we will discuss the requisites for a valid exercise of criminal jurisdiction. First, we have jurisdiction over the subject matter. Again, jurisdiction over the subject matter. Second, jurisdiction over the territory where the crime was committed. Again, jurisdiction over the territory where the crime was committed. And third, jurisdiction over the person of the accused. Again, jurisdiction over the person of the accused is the third requisite for a valid exercise of criminal jurisdiction. How jurisdiction over the subject matter is conferred? Again, how jurisdiction over the subject matter is conferred? Jurisdiction is conferred only by the Constitution or by law. Ulitin natin. Jurisdiction is conferred only by the Constitution or by law. Halimbawa, Batas Pambansa bilang 129 as further amended by Republic Act number 7691 o ang tinatawag na Judiciary Reorganization Act na kung saan nakalagay sa batas na ito kung ano ang mga kasong sakop ng jurisdiction ng Regional Trial Court o Municipal Trial Court. Statute applicable to a criminal action. So jurisdiction over the subject matter is determined by the law in force at the time of the commencement of the action. Again, jurisdiction over the subject matter is determined by the law in force at the time of the commencement of the action and not at the time of its commission, even if the penalty that be imposed at the time of its commission is less and does not fall under the court's jurisdiction. Upang malaman natin kung ang isang particular na kaso ay under ng jurisdiction, halimbawa ng RTC o MTC, ang batas na sinusunod ay yung batas na umiiral sa panahon na isinampa ang kaso, hindi yung batas noong panahon na ginawa ang isang krimen. Jurisdiction over the territory where the crime was committed. What is the general rule on jurisdiction over the territory where the crime was committed? It is a fundamental rule that for jurisdiction to be acquired by courts in criminal cases, the offense should have been committed or any of its essential ingredients took place within the territorial jurisdiction of the court. Territorial jurisdiction in criminal cases is the territory where the court has jurisdiction to take cognizance or to try the offense allegedly committed by the accused. Ibig sabihin, kung saan nangyari ang krimen, doon mo rin isasampa ang kaso. Kung halimbawa, nangyari ang pagpatay sa Manila, edi sa Manila RTC mo ipafile. Because the rule in criminal cases is that venue is jurisdictional. Ulitin natin, venue is jurisdictional in criminal cases. But in every rule, there is always an exception. So exception is Section 9 of Republic Act number 8042, the Migrant Workers Act of 1995, which provides that a criminal action arising from illegal recruitment shall be filed with the RTC of the province or city where the offense was committed or where the offended party actually resides at the time of the commission of the offense. And criminal action sa illegal recruitment under Section 9 of Republic Act number 8042, Migrant Workers Act of 1995 ay pwedeng isampa sa RTC kung saan nakumit ang illegal recruitment o sa RTC na nakakasakop kung saan nakatira ang biktima. Halimbawa, kung ang illegal recruitment ay nangyari sa Manila at ang biktima ay nakatira sa Oriental Mindoro, ang biktima ay may options na mag-file ng kaso sa RTC Manila Manila kung saan nangyari ang illegal recruitment o RTC sa Oriental Mindoro kung saan nakatira ang biktima. Again, jurisdiction over the person of the accused is acquired upon his arrest or upon his voluntary appearance. Other terms used for voluntary appearance could be voluntary surrender or voluntary submission. What is the general rule? Seeking affirmative relief is deemed to be a submission to the jurisdiction of the court. The voluntary submission may be effected by filing a motion to quash, appearing for arraignment, participating in trial, or by giving bail. So ang general rule sa voluntary appearance, halimbawa, kinasuhan ka at nag-file ka ng motion to quash, o halimbawa, dumating ka sa arraignment mo sa iyong kaso, o nag-participate ka sa trial, o nag-post ka ng bail, ibig sabihin, may voluntary submission ang accused sa jurisdiction ng korte. Sabi ko nga, bawat general rule may exception. So, exception by special appearance. In cases of pleadings whose prayer is precisely for the avoidance of the jurisdiction of the court. These pleadings are, in criminal cases, motion to quash a complaint or information on the ground of lack of jurisdiction over the person of the accused, and motion to quash a warrant of arrest. Exception, may tinatawag tayong special appearance seeking affirmative relief. Halimbawa, nagsampa ka ng pleading sa korte para questionin ang jurisdiction ng isang particular na hukuman. Tulad halimbawa, kung nag-file ka ng motion to quash a complaint or information on the ground of lack of jurisdiction over your person. Ang reason mo for filing is naniniwala ka that you were illegally arrested o ang pag-aresto sa iyo ay illegal. O halimbawa, nag-file ka ng motion to quash the warrant of arrest issued by the court. Sa dalawang pagkakataon na ito, kahit na nagsampa ka ng pleading sa korte, hindi yun matatawag na voluntary submission sa jurisdiction ng hukuman dahil ang purpose ng iyong motions to quash na ipinail sa korte ay para questionin mismo ang jurisdiction ng korte over the person of the accused. Nakakaintindihan po ba tayo? Ayan, very good. So let's proceed. What is principle of adherence of jurisdiction? When you say principle of adherence of jurisdiction, it means that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do in the exercise of that jurisdiction. Ibig sabihin, kapag ang isang hukuman ay nagkaroon na ng jurisdiction sa isang particular na kaso, yung jurisdiction na yun ay i-exercise na ng korte hanggang sa matapos nito ang buong proseso ng pagdinig at makapag-issue ng desisyon sa kaso. Ito ang tinatawag na principle of adherence of jurisdiction. So by Amisai, that is the part of our discussion on general principles of the rules on criminal procedure. Please do not forget to subscribe my channel and hit the notification bell below to keep you updated of our lectures and videos. Have a good day, my Amisai.